If a doctor refuses to recognize a textbook as being authoritative, can I still introduce it into evidence at trial? You want to know the answer? Come join me for a moment as I share with you some fantastic information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. During the course of trial, there's one key reason why I want to introduce a textbook as being authoritative. Why is that? Because I want the doctor to recognize that this is a book that he recognizes as being an authority in the field. Once the doctor accepts and acknowledges that a textbook is authoritative, I can then use sections of that textbook to now cross-examine the doctor and ask if he agrees or disagrees with it. Now imagine what's going to happen in front of the jury. Doctor, you've now recognized that this textbook is authoritative. Okay, turning to page 72, Dr. Jones says that X, Y, and Z. Do you agree or disagree with that statement? Oh, I disagree. So once I get the doctor to disagree with certain statements made in the authoritative textbook, now I have the ability to show to the jury later on during closing remarks that here, this doctor is disagreeing with a noted authority, that here's the expert in the country. He has recognized that this doctor is the expert in the country on this topic. And here comes Dr. Jones. And what credentials does he have? Did he author this textbook? No, he didn't. Did he do anything else similar to show that he's an authority in this field? No, he didn't. And yet here he is. He's disagreeing with this noted author as an authority on this particular topic. That's why you will rarely find a doctor who gets on the witness stand to testify that he recognizes any textbook as being authoritative, even though he has this own textbook in his own office. He uses it to teach their doctors in training, known as residents, and that he often will refer to it when treating patients. And the reason that they will say it's not authoritative, and this is great, is because the moment it comes out in print, it's already outdated, and there are always updates being given. And the textbook that you're referring to is already outdated by a few years. That's why the doctor will always say that a textbook is not authoritative. But the real reason, the real motivation why they are doing that is because they don't want to be cross-examined by the information contained in this textbook. Because once they say, yes, it's authoritative, now everything is open to cross-examination. And even if we try and give them the caveat that says, listen, doctor, do you agree that this textbook is authoritative? No, I don't. Do you agree that certain portions of it are authoritative? No, I don't. Because again, he's trying to weasel out. If he says yes, now I can use selected portions, giving and reserving his right to disagree with me and disagree with what's contained in it. He never ever wants to say, yes, this is an authoritative textbook. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in a medical malpractice trial here in the state of New York. You know, in all likelihood, you've got questions or concerns about your own particular matter. Well, if you're contemplating bringing a lawsuit for something that happened to you here in New York and you've got questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, there's something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.